Great, thank you. Well, hello to everyone who's already in attendance and to everyone else who might be watching the recording or joining as I get us started. Today, we're here to talk about energy and the public interest, especially kind of a look back on the past 5 years since Senate Bill 52 passed in 2021. We're going to be talking about all things energy siting at the Ohio Power Siting Board. At the Ohio Environmental Council, our engagement on this issue has been primarily around solar cases. So we'll be talking about it in the context of solar cases, but a lot of what we'll be talking about is also applicable to other forms of electric generation as well that might go through the Ohio Power Siting Board process. For those of you who are maybe tuning into something with the Ohio Environmental Council for the first time, we are a statewide environmental nonprofit organization based in Columbus with staff throughout the state, focused on a clean, healthy Ohio where our democracy empowers all communities to thrive in harmony with the environment. And we do this through protecting the environment, through legal and policy advocacy, decision maker accountability, and civic engagement. And that's part of what we're doing here today, talking about legal and policy advocacy, decision maker accountability, civic engagement, talking to you all about a really important issue when it comes to how electric generation and energy is sited here in Ohio. We're really excited to have you here with us. A few logistical things before we kind of dive in. If you are an attorney here seeking CLE credit for this webinar, for the first one of 2026, it is free. So all you got to do at the end of this webinar, if you're an attorney seeking CLE credit, is complete the survey that will ask you a few questions about the webinar. And then also you'll provide your attorney ID number to us so that I can submit your CLE credit after the fact. And then also throughout the webinar, we'll have a few poll questions. For those of you who aren't attorneys, this is something attorneys are used to. We have poll questions to just track your attendance throughout the webinar. If you're not an attorney, feel free to complete the polling questions too. Some of them are actually kind of testing a little bit of your knowledge on the issues we're talking about today. But it's up to you. You don't have to. If you're an attorney, please do complete the poll questions. And with that, I think we will dive into the actual content for today as well. So we're going to be starting by talking about the aftermath of Senate Bill 52 from the 134th Ohio General Assembly. Joining me today in this discussion, so I'm Chris Tavenor, Ohio Environmental Council's General Counsel. I use they, them pronouns. I've been working at the OEC since about 2017, and I've been part of our team that's been doing legal work at the Ohio Power Siting Board and the Public Utilities Commission for that entire time. With me as well are two of my colleagues who will be joining this discussion and this presentation. Actually, Karin and Nolan, if you both want to just briefly introduce yourselves and the work you do, go ahead.
Hi, everyone. My name is Karin Nordstrom. I use she, her pronouns. I am the senior attorney for clean energy here at the Ohio Environmental Council. And so I am very active in representing the Ohio Environmental Council before the Ohio Power Siting Board, which cites all utility scale power here in Ohio.
Hey everybody, Nolan Rutschilling. I am the Managing Director of Energy Policy for the Ohio Environmental Council. I lead our energy team and work with our law center in the regulatory and legislative spaces, focused on ensuring Ohioans have clean, affordable, and reliable power. So I spend most of my time, certainly working with Karin and Chris in the legal space, but a lot of my time is actually at the legislature. So that's the perspective I'm hoping I can bring today.
Thanks, Nolan and Karin. So you'll be hearing from all three of us throughout this presentation, as well as when we get to the Q&A session at the end. Definitely feel free to use the Q&A tool through the webinar process to drop questions. If some of them seem like things we can answer in the moment, we might get to it in the moment. Otherwise, we'll get to your questions at the end. All right, so I'm going to move us right along. Okay, so some of you may be familiar with the Ohio Power Siting Board. If you are not familiar with the Ohio Power Siting Board, we're going to give you a very, this is like the 2-minute, 3-minute rundown on a very complex administrative agency, just so you have a little bit of a baseline of some of the issues and terms that we're going to be talking about today. So at the Ohio Power Siting Board, a electric generation facility is working on a project. Maybe it's a solar facility, maybe it's a natural gas plant, maybe it's a wind farm, whatever it might be. They put together a complex application of materials. There's a whole Ohio Administrative Code section that outlines all the materials that needs to go into the application. They put that application before the Ohio Power Siting Board, and they create a case before the board. Then after they've done that, they have a number of requirements they have to meet, including public meetings out in the community where the project is. They may have data requests from the Ohio Power Siting Board, but then organizations and individuals that are potentially impacted by the project can legally intervene in the case. That's what Ohio Environmental Council does sometimes for some of these cases, and other organizations and individuals do as well. The Ohio Power Siting Board staff, who you'll hear us talk about quite a bit, staff does a review of the project and produces something called the staff report, which is assessing essentially the sufficiency of the project to meet certain statutory legal criteria. Importantly, Ohio Power Siting Board staff is separate from the board itself in the sense that the staff does that assessment and provides that information in the case, separate from the actual decision makers of the Ohio Power Siting Board. The Ohio Power Siting Board is made up of agency heads that are appointed by the governor, also includes the Public Utilities Commission chair, and some non-voting members from the legislature. And in certain cases, which we'll talk about a little bit later, there can be some local township representation on the cases too. So after the intervention process has occurred, staff has put out the report, there is an official public hearing where people in the community where the project is, they can come forth, submit public comments. Those become part of the evidentiary record. And then the applicant may go through some settlement discussions with the other parties in the case, but then ultimately it leads to an in-person evidentiary hearing that occurs at the Ohio Power Siting Board at their offices downtown in Columbus. After that evidentiary hearing occurs, where you've got experts from the applicant put forth, experts from intervening parties, you have legal briefings that you've got all the parties, depending on their positions and what they're putting forth. They write legal briefs like any attorney might in another case, arguing for, if they think the project should be approved, denied, maybe conditions should be modified. There's a lot of different approaches and positions that parties could be taking in these cases. And then after all the briefing concludes, the Ohio Power Siting Board members, those agency heads and the commission chair, take a vote and issue a written decision explaining their justification for why they made the decision they did under the law. And then after the board has made its decision, those decisions can be first appealed once back to the board. So parties may say, hey, board, we think you got it wrong and here's why. And then the board considers that appeal. Almost always they end up just affirming the decision that they made previously because it's the decision they already made. Sometimes they'll change it, but that's pretty rare. And then after those appeals, that one single appeal to the Ohio Power Siting Board, parties can appeal directly to the Ohio Supreme Court itself. So SB 52 is a bill that was passed back in 2021 that modified slightly how the Ohio Power Siting Board related to electric generation facilities. And in the case of SB 52, specifically wind and solar. So the law gave local elected officials kind of two new powers in large-scale renewable energy siting before the board. So specifically, county commissioners can create renewable energy restricted areas for any future utility scale renewable energy projects. That was an amendment to ORC 303.58. And then county commissioners and township trustees can appoint an ad hoc voting member to the Ohio Power Siting Board. So in this instance, I listed out kind of the general idea of who's on the board for voting purposes. Township trustees can be appointed to actually be a voting member for these types of projects. These changes, importantly, only apply to renewable energy projects, which, at least from my perspective, and I think Nolan and Karin's perspective, seems a little bit biased against those projects. And maybe there should be some, if we're going to have this, maybe it should apply for all types of energy. But ultimately, as the law is written right now, these changes are only for renewable energy projects. And then local communities can attempt to overturn renewable energy exclusion zones through referendums on the ballot. This was attempted in Crawford County back in 2022, and there's actually an active campaign right now in Rutschilling County to overturn an exclusion zone this year. I believe it's going to be on the May ballot. Nolan, you can correct me if that's wrong. Yeah, Nolan's giving me a thumbs up. That's on the May ballot. So SB 52, very importantly, did not make any changes to the statutory prongs for what the board is supposed to assess when it comes to an electric generation facility. So there's 8 prongs in the law. Uh, these are slightly abridged versions because some of them are much lengthier than this, so I abbreviated them for the sake of what content we're trying to provide you all. You don't really need to know all of these for what the conversation, but this is just to illustrate the board has 8 specific prongs that they are supposed to walk through, and the board staff, their staff report makes recommendations based on these 8 prongs. In my experience, these prongs are almost always met by projects in the sense that they provide sufficiency. The applicants provide sufficient information for almost all of these prongs. What ends up happening in almost all of the cases, at least that OEC has been involved in, the discussion ends up focusing on one specific prong, which is prong 6, that the facility will serve the public interest, convenience, and necessity. So what we're going to be talking about today is very specifically about how the Ohio Power Siting Board, the Ohio Supreme Court, has been handling this question of public interest since SB 52 has passed. Because prior to SB 52, there was a way that public interest was handled. After SB 52 was passed, there is a different way that SB 52 was handled. And what we're one of the things we want to really point out in this initial part is the law, SB 52, did not change any of the language in this section. There was no change to the public interest analysis or any of these other prongs. There was just a change in other public participation opportunities, such as providing those ad hoc voting members for the trustees and the county commissioners. So, just to kind of hit that home, SB 52, as written, the law was only supposed to impact the OPSB's operation in 2 key ways. Provide for local input through the participation of ad hoc board members in solar and wind cases. And then also it grandfathered specific cases that would be eligible if they hadn't been grandfathered. If a county or a township were to pass a solar and wind exclusion zone, then those projects would be banned in those townships. But when SB 52 was passed, there was specific language included in the bill indicating that certain cases that hit certain criteria would still be able to be cited under the Ohio Power Siting Board, even if a county created an exclusion zone. Essentially, that was a compromise that the legislators created in order to kind of reflect that there were a bunch of companies that had already expended significant resources to go through the process already for certain requirements that they needed to do. And we're kind of at the tail end of all of those projects that hit that criteria. We might come back to this point later because, in effect, there were a number of cases that still got denied as a result of the issues that we're going to talk about. So that is kind of bringing us back to the question of the day. I'm about to pass it over to Karin for this next section, but we're really going to be focusing in on this RC 4906.10A6, this public interest prong, where we have that the board shall not grant a certificate for the construction, operation, and maintenance of a facility unless it determines that the facility will serve the public interest, convenience, and necessity. And so the question of today is, what does it mean for a facility to be in the public interest? OEC, we have our position. We're going to talk about what that position is, what we've argued for. We're going to talk about what board staff has said, what the board has said, what the Ohio Supreme Court has said, and hopefully illustrate to folks on this webinar that it's the current legal circumstance we're in on this issue is kind of creating a little bit of an absurd result. We'll get there. Hopefully you see the logic that we're kind of outlining. And at the end of this, we're going to talk about some of the thoughts we have, and hopefully you all may have some thoughts too on, maybe this law and how this is approached needs to change because it's creating some really, really weird situations. So with that, I am going to pass it over to Karin. Just a note, as I said, our experience is coming from solar cases. We'll be talking a lot about solar cases, but we really do think this kind of the issue that we're kind of focused on here implicates really any type of energy generation that Ohio might need at this moment. So Karin, take it away and just prompt me when you need me to advance a slide.
Great, thanks, Chris. So the public interest since SB 52, we're going to go through a variety of different perspectives from different actors in the legal space, starting with the Ohio Power Siting Board staff themselves, and then the board, and then the Supreme Court, just sort of following the trend of how a case adjudicates. And so, like Chris said before, the Ohio Power Siting Board staff are effectively a party to the case. They are able to join settlement agreements. They provide testimony in the case, and the AG's office on their behalf provides briefing. So they are an active party to the case. And as Chris said, pretty early on, prior to taking public testimony, the staff issues a report. And in that report, it issues recommendations on every single one of those 8 statutory prongs in 4906.10. And that includes the public interest. Most of those statutory prongs are very technical requirements, and staff consists of engineers, geologists, environmental resources grads, a lot of technical experts, and they provide recommendations on whether or not they think that the company, the applicant, has satisfied those technical requirements and additional conditions they think that the applicant should have to follow throughout construction and operation and maintenance to be able to fully comply with the statutory prongs. And then they have this more sort of discretionary prong that's much less technical in a sense, as the public interest, convenience, and necessity, which Chris previewed. And so since SB 52, the staff report has taken public opposition in itself, the presence of public opposition, as much more persuasive as it has in the past. So comparing some of the solar cases that you've seen adjudicated, or that we've all seen adjudicated at the board post SB 52, local opinions have been given much more weight and deference, or opposition generally has been given much more weight and deference than, say, natural gas pipeline cases prior to SB 52, where you also see a good amount of local public opposition, or had seen in the years leading up to SB 52. And so, this has, slowly increased, I would say, and staff's opinion has evolved to look at local electeds as the bellwether for the overall public opinion in local areas. And so recently, in the Carnation Solar case, which is still pending, still in briefing before the board, under cross-examination, the staff lead for that project did say that the staff considered the presence of opposition in itself a public interest impact. So the reasoning behind the opposition, regardless of what the reasoning actually is, there's still a public interest impact in the fact that there is opposition in itself. And like I said, staff has started to look to local government opposition as dispositive to the public interest prong as a whole. So if the county and townships where the project is proposed have all filed resolutions in opposition, then the staff will recommend denial of the program on the public interest prong alone. And that's really the trend we've seen, that the technical requirements are always met. Staff recommends that those are met, and then recommends denial on the public interest prong when we see this unanimous local government opposition. Staff will also send out letters to to the local government officials and let them know that they should make their voices and opinions heard prior to the deadline of the staff report. And so, they reach out, they try to get a feel for what the local governments think, and encourage them to publicly voice their opinion before there's a public hearing where folks provide public testimony, and before the evidentiary hearing occurs. So we really don't see the balancing described or contemplated in these staff reports between the actual benefits of the project compared to the concerns raised by the opposition. Like I said, staff is full of a lot of technical experts who do have the ability to sort of weigh the substance of the concerns presented. But we don't really see a lot of discussion about that in the staff report. We more see a tallying of, this is what people have said. And there's unanimous local government opposition. These are the resolutions that have passed, and recommend approval or denial based on that. So we can move forward, Chris. And the Ohio Power Siting Board looks to staff as an incredibly persuasive voice in their decision making, and really. Since SB 52, I cannot think of a case where they have broken with staff. Prior to SB 52, I also cannot think of a case where they've broken with staff. I'm sure there is an example out there somewhere, but really, in practice, staff's recommendations carry the day in most circumstances. And so the board's reasoning has been quite similar to staff's. In recent decisions, such as Fraser Solar, the board has said, well, not even just recent decisions, but the board does pay, a good amount of words or explanation to saying that this should be a broad lens to examine the public interest, and that it's not a mere tallying of opposition. However, the outcomes really seem to follow the opinions of the local governments. And so, in Fraser, the board said that projected benefits of a project against the magnitude of potential impacts on the local community is really what they're looking at when they're evaluating these cases. And so that's, magnitude of potential negative impacts is really, the sort of legal standard that we're supposed to be balancing and discussing in briefing to the board. We want to go next, Chris. And so then, many of these cases have made it to the Ohio Supreme Court. To date, all of the cases that the court has decided are cases where the OPSB had approved the decision below, and we are still waiting for or had approved the certificate, the application below. And so we're still waiting for a case of first impression to provide guidance on the meaning of public interest when the board has denied a project or application based on this sort of new approach that the board has taken with respect to the public interest prong. That is in part because the first case of first impression, the developer withdrew because this is, I don't know for sure, but my understanding is that it was just not financially, it could no longer financially continue to keep its place in line in different regulatory venues. And so it just was not financially feasible to wait for the board's decision. Pardon me, the Supreme Court's decision. So the case that we are waiting for as the case of first impression is called Kingwood Solar. It was argued quite some time ago. I understand that one of the cases argued on the same day as Kingwood had a decision come out in February. So truly, we are looking to see any day whether that Kingwood case will come forward. The developer has requested an expedited ruling because it too is now the economics are getting difficult as it waits for a decision. So stay tuned, and it could come anytime. It could come with the batch of decisions dropped tomorrow. Who knows? But what we know about what the court has said so far is a much sort of stronger endorsement of a broad lens approach to the public interest that is consistent with OPSB's stated precedent. And so most recently in the application of South Branch Solar, the Supreme Court said that while local government and public input regarding a project is certainly informative, it is not in itself determinative of whether the proposed facility would serve the public interest, convenience, and necessity. And the Supreme Court has also consistently stated that Section 4906 authorizes a dynamic citing process that does not stop at the certificate and gives the board the ability to impose conditions when it enters into a certificate to allow for ongoing monitoring and compliance as the project proceeds. So a project is not, it gets a certificate and then the board says, see ya, good luck on the project. It's a very dynamic process which requires a number of conditions and continued staff involvement, and a complaint process that anyone can exercise in addition to those sort of staff monitoring checkpoints. So it's not a static process by any means. We can go forward, Chris. And so following South Branch Solar, what happened? OPSB did not take it as particularly relevant or persuasive, the guidance that the court laid out in South Branch Solar. And the staff report in the case to follow at the OPSB after the South Branch decision came down, it's called Crossroads Solar. And in that case, the staff report actually changed its recommendation. So it had recommended approval based on all the technical requirements and then also based on the public interest, convenience, and necessity. However, following the issuance of the staff report, one of the townships that had remained neutral on the project changed and issued a new resolution that was non-unanimous. Two of the township trustees voted for it. One of the township trustees voted against, saying that he still very much believed that the project, that the full opinions in the township were actually still very mixed 50-50 on the project. But the issuance of this non-unanimous resolution resulted in unanimity across the townships where the project resided and the county where the project resided of opposition. And so staff changed its recommendation, which is relatively unique. It's happened only once in renewable energy cases before, and maybe in other cases, but it's quite rare. And the board said, the presence of opposition in itself was persuasive. So the board followed across the staff recommendation of denial, and in its decision said, while the board is not particularly compelled by some of the evidence that the opposing interveners put forward, the fact that they went to great lengths to create this evidence is in itself persuasive evidence that we should turn down this project. So they said that the substance of the concerns raised by the opposition were not necessarily, persuasive or grounded in the facts in the evidentiary record. However, just the passion alone is enough to deny the project. And in the press release the board said that it noted that any positive benefits for the project are outweighed by the consistent and substantial opposition by the area residents. And here's the important part, as expressed through the local government entities. So really it's just a tallying. From our perspective, from our read, we see the staff effectively tallying the resolutions. And if you hit all resolutions opposed, then it tips it over and it becomes a project that's not in the public interest, convenience, and necessity, ignoring statewide benefits of clean energy to mitigate climate change for all of us and for all of our industries, including the farming industry. All of that is no longer carries weight. It's just a dispositive finding against public interest. We can go. So what has the Ohio Environmental Council said? So we're the ones putting on the webinar here, and we've submitted several briefs in these cases. And the Ohio Environmental Council does a pretty thorough review of applications, engages in settlement discussions, and works to find conditions and projects that balance mitigating the serious concerns raised by folks living around the project and the overall statewide need for clean, affordable, renewable energy. And so what we've said is really a focus on reviewing the substance of both support and opposition and weighing the substance of those concerns against any mitigating conditions that are available and that the applicant has agreed to. So, in that calculation, statewide impacts do matter as much as local benefits and impacts. And it's really about balancing those against each other and being able to mitigate any impacts. And that it all deserves a substantive analysis, and keeping in mind the dynamic process of the siting. It's not, where in other administrative venues where it's adjudicated and then the administrative body is no longer really has its hands in say your Social Security every week, or your labor complaint. They issue a decision, and that's it. It's really a much more hands-on approach that the Ohio Power Siting Board maintains, and that local sentiment is incredibly important and informative, but cannot be in itself dispositive just in its mere presence. And, if local impacts are truly severe, the board should be able to demonstrate those severe impacts beyond just pointing to the existence of opposition, that this really needs to be a more substantive discussion, because we have seen local concerns result in changes and to project design. When these utility scale solar projects were first coming online, they were, with much shorter setbacks. Their fencing was, something that local residents really saw as unsightly. And so they've changed, setbacks have changed, fencing has changed. There's been a huge movement towards agrivoltaics, so finding dual use for farming and while panels are in place. And Ohio is now one of the leaders in row crop agrivoltaics research. And so, this substantive review is important and can lead to improvements. And so that's why, we push for the substance. Chris, do you want to? Yep. So, what's to come? So, of course, we have Kingwood at the Supreme Court, which, could change the landscape depending on what the Supreme Court says. We also have some appeals of cases that have been approved. So Fraser Solar, Eastern Cotton Solar, Tail Solar, and Oak Run, which would have a very large agrivoltaic row crop component. And then at the Ohio Power Siting Board, there are several cases somewhere in the adjudication stage. So Hill Climber Solar and Hamden Energy are both in application phase. So no staff report. None of that has happened yet. Carnation Solar is currently in briefing. It has a recommended denial from the staff report. Sloopy Solar is about to have its public hearing next week. And also has a recommended denial by the staff there. Crossroads Solar, which we mentioned before, staff changed their position based on a non-unanimous resolution. That has been denied by the board and is in the application for rehearing stage. And then there are several new natural gas projects popping up. Many of them as planned as co-located with data centers, and one of those has been approved. However, I do believe there is at least one natural gas plant in application stage that is not a co-location request and is just a standalone natural gas plant to go into the transmission system. And so that's what we have to look forward to, and that's sort of the state of the legal cases to date. Okay, so what does this mean more broadly? We've been talking about solar. The focus has been on solar because those are the applications. We've not really seen natural gas applications until recently. And so, what does this mean as other forms of fuel start to apply to the Ohio Power Siting Board? And the truth is that the board's current approach, the staff have said under cross-examination that their approach is the same regardless of fuel source. And so the board's current approach could lead to every application being denied as long as there is a passionate and outspoken enough group that can persuade their elected officials to file a resolution in opposition to the project.
Thanks, Karin. And I'll just, Nolan, you can weigh in here too. And Jessica, if you could prompt the first polling question while we kind of talk. I think one of the things that I've been thinking about on this issue, Karin, and I want both you and Nolan's thoughts on this as we kind of move into the next part of our discussion. There's this question about, okay, if every future utility scale electric generation facility receives sufficient local opposition, no new electric generation could be approved. There's a world where the board does actually follow its logic that it's been applying in solar cases. And if opposition appears in these natural gas cases or other forms of electric generation, they actually follow their logic and none of these cases get approved if the same sort of facts occur. There's also a world, though, where they actually end up creating different logic for other types of electric generation where they say, oh, we treat natural gas differently than solar and wind. And that creates its own kind of host of problems. I'm curious if either of you have thoughts on that outcome.
I think there's a potential third outcome there, Chris, where they don't explicitly say we treat natural gas and renewables differently, but find sort of different distinguishing factors among the cases to tease out, before settling on this sort of all resolutions are negative is dispositive. The board did go through some iterations of sort of teasing out what it believed um, uh, uh, public interest meant, and board staff in particular, what it believed public interest meant, and sort of parsing between cases in a way that wasn't always the easiest to follow as a practitioner in the space. And so I think it's possible we would see some sort of parsing like that that's able to find some sort of distinguishing factor among the cases to distinguish natural gas without saying out and out, we're going to treat natural gas differently. I think that's the most likely outcome. But based on what they've said, this analysis applies regardless of fuel source, and so at this point, I think we could anticipate that they would follow that precedent and deny.
Nolan, do you have any additional thoughts?
I don't have too much to add beyond I think we're at a real crunch point here where we are seeing significant demand growth. We're using more, meaning we're using more electricity than ever before. Data centers are obviously the topic of that conversation, the main focus of it, anyways, but it's happening regardless of the data centers. And even if the OPSB were to do what I agree with Karin is likely, natural gas does not is not as quickly built and deployed. Natural gas generation is not as quickly built or deployed as solar or wind or battery storage could be for multiple reasons. One of which the turbines, the mechanism used to generate the electricity that spins, that's used by burning the natural gas. There's a huge supply chain crunch in for the United States and for the world. So even if the board's approach is a different standard for natural gas, we're not going to see natural gas projects come online in a way that meets our concerns around reliability and really our concerns around cost. So we can't, I think there's, and Chris, you'll probably get into this, but I think there's a sense in the legislature that we'll just build more natural gas. The data centers can build their own power. But we literally don't have the supplies to do that in the short term if we want to meet the capacity crunch we're under, which is driving up our costs. So there's a real risk there.
Well, I think that moves us into the second part, and I know we're running a little short on time. I think also folks got the right answer, so good job. Um, uh, and Jessica, as we enter this next part, I actually forgot to prompt us on the first question earlier. So Jessica, if you want to prompt the second question now as well. Nolan, this next part, we're going to be talking about what like a new framework could maybe look like for the public interest. And so as we get into that conversation, you're the one out of the three of us, you're the one that talks with legislators the most. What do you think the appetite is for new policy around electric generation in Ohio?
I think the legislature just passed House Bill 15 about a year ago, last May, that did open up some unrelated to SB 52, some other hurdle. It kind of removes some hurdles for permitting and siting for generation, particularly for fossil fuels, but a lot of it's fuel neutral as well. So, the legislature has acknowledged the need to bring on more generation, but I think the legislature is very split on how to do that and what fuel sources there are. So privately, I think legislators might see the need, but I think the leadership, particularly in the Ohio Senate, is still pretty hesitant to embrace clean energy and sort of in terms of any kind of reform or repeal of SB 52. I think it's a longer term prospect and unlikely that we could see that this General Assembly, which ends this calendar year. However, there's a clear need, and groups like ours, our group we partner with, the Ohio Business Energy Partnership, the Ohio Chamber, the Ohio Business Roundtable, are all pointing to the need for what they would frame it as siting reform or permitting reform. But it's basically just the fact that we need to get more energy online. So we're in the midst of a kind of like a rock in a hard place where maybe politically some of the legislators don't want to reopen this issue, but a lot of parties are calling for it.
Thanks, Nolan. So we've kind of been teasing this for a little while now, but what we want to talk about, for this last part is really just some thoughts on what a legislative fix to this question might look like. Legislative, or maybe the board were to adopt a new philosophy in the future as well. So this really focuses on this RC 4906.10 A6 section, where right now the language just says the facility will serve the public interest, convenience, and necessity. No definition, no explanation as to what that should mean. And so the board has taken its approach that it has taken on what that language means. And so back in 2022, the Ohio Power Siting Board, after SB 52 was passed, was revising its administrative rules, including language about how applications are supposed to occur, how the staff report works, all the things that go into the Ohio Power Siting Board process. And at that time, I like to think we were maybe a little bit prescient as to what issues were going to occur over the next few years. But we, as a team, submitted comments to the OPSB regarding those rules and actually made a recommendation at that time about a different definition for the public interest, convenience, and necessity. And you can see we focused on that broad balancing of factors language, really trying to codify the Ohio Supreme Court's approach a little bit more into the rules themselves, a broad balancing of factors beyond counting comments in support versus opposed. The factors that they should be thinking about are, from our perspective, like, does the project mitigate climate change? Is it maintaining market competition? Is it ensuring electric reliability? Is it accounting for safety issues? Like, those issues should be weighing into the public interest calculation, as well as like, what's the economic value that's being brought to the local community or the statewide community? All of these different factors matter. And we were trying to set some boundaries and scope to really make recommendations to guide the board on how it should be making its decision. At the time, they just fully rejected everything that we proposed for public interest, though we had a bunch of other recommendations we made, and I think they actually did make a few modifications in some other areas, but they did not adopt our public interest definition here. And so we've learned a lot over the past 5 years, and Karin can speak a little bit more to this. But we've been thinking a lot about this public interest question. You can see it in the way that we do our briefs. You can see it in the way that we're talking about it now. We really think that what's missing here is that the reality of electric generation needs for the state needs to be truly balanced against the local impacts, and really look at there should be some sort of really kind of guiding standard that requires determining real impacts and not viewing the existence of opposition itself as an impact. Really, there can be really real local impacts that like are very clear. And it's like, what, this project's going to do X, Y, Z in the local community. It needs to be denied for those reasons. Those are real things. But there are also real statewide benefits that when you're looking at a project and you're like, okay, look, the local impacts are minimal. And there's mitigating tools that we can use to mitigate that. And the statewide benefit here is significant. And there should be a world where that can also be approved for those reasons, even if some impacts exist at the local level. And so that's why we really focus on this idea that no one factor should be determinative over the other, because that really allows for some really, what we consider to be potentially an absurd consequence. We talked about earlier where electric generation, we could have a world where if every single project sees local opposition to a certain scale, They just all get denied, and then suddenly we have no electricity in Ohio, and that would not be a good thing for the amount of electricity that we use on a daily basis. And ultimately, also, the substance of public opposition slash support matters just as much as quantity. Uh, Folks are going to oppose natural gas plants. You know, we as an organization obviously think that people should be moving toward clean energy and not toward fossil fuels, but opposition to a natural gas plant should also be grounded in the science. If the board did deny a natural gas plant, their reasons should be grounded in the science and the impacts to the state and the local community, not just the tallying of opposition. So Nolan, you've talked about, we wanted to quickly give a moment to also just call out, like, there are some other legislative fixes for electric generation that could really benefit local communities. So do you want to take a moment to kind of talk about those?
Yeah, and I'll be brief. If you look on our OEC's website and our Action Fund website, the OEC Action Fund website, you'll find more information about these bills. But really briefly, there's other mechanisms to try to address this issue. There's a piece of legislation, House Bill 303, that establishes community energy. That's effectively for a renter or a homeowner or just a resident who maybe doesn't want to put solar on their roof. They don't own their home. They don't want to pay that upfront cost. It allows a customer to subscribe directly to an energy project in their community, so in their county or a contiguous county, and effectively see the same cost benefit they would see as if they had a solar array or other generation on their property or in their community. So effectively, a way to it just opens up a new mechanism called virtual net metering that we don't have in the state of Ohio that allows folks to subscribe directly to a specific energy project. So it's a pilot program, a lot of really interesting components there. That bill is currently in the Senate Energy Committee. It has passed the House. There's also a piece of legislation coming forward in the Ohio Senate and the Ohio House that establishes plug-in solar, which is a smaller scale solution, but one that can be quickly deployed and is very equitable. It effectively allows solar generators to be, you could purchase it at a hardware store, bring it home, plug it into your house, and set it outside. And what that would do is just offset some of your energy use. So it's no different really than using a generator, but it's just always drawing energy whenever it's feeding into your house, and it's lowering your electric bill. So I could buy a panel. It has an inverter. I plug it into the wall or something outside, set it on my balcony, and then maybe it's offsetting some of my appliance usage and some of my electric usage. And you can see a really immediate payback that way. But you just need legislation to get past the interconnection process and some legal barriers that are currently there. So this is legislation that's passed in Utah, in Virginia. It's been proposed in many other states. Don't know if it will go anywhere in the next year, but I think it's going to be a hot topic. And it's a very sort of common sense solution that anyone, whether or not you own your home, can use. So those are two quick overviews of some legislation that ties to generation.
So I think we're probably going to move through some of these discussion questions for interest of time and get to kind of our final piece here. But I do want to kind of just throw these up on the screen for folks to be thinking about, which is, just these are the questions that we're thinking about on a daily basis when it comes to these issues. And, we've kind of touched on them some in different ways. And it's, just things to think about and sit with as you consider this issue. Like, what role should public input play? How could the board weigh both statewide public input alongside local public input? The nature of having one factor determinative over another, whether or not certain forms of electric generation should be viewed differently than others. These are all questions we're constantly thinking about. And if legislators do approach a legislative fix, these are also questions that they need to be thinking about. And if we were to engage in testimony in those new bills, like, these are all the questions that are going to be super important as this discussion evolves over the next few years. But what we do have here at the end, and Karin, maybe you want to kind of take this. We do have kind of, essentially, if we were to start writing language, this is an idea of where things could start. This is an example of an approach you could take. But Karin, do you want to kind of talk through what we have here?
Sure. So, somewhat reflective of what we proposed to the Ohio Power Siting Board in their 2022 rule change proceeding, something that focuses on and codifies the broad lens perspective, um, uh, highlighting that both statewide and local benefits must be considered, and that benefits and impacts to be considered sort of non-exhaustively. Some to put forward that must be a part of the conversation include climate change, grid reliability, affordable access to electricity, mitigating local viewshed nuisance, etc. Safety. Oh, yes, we did write safety down in that. And that, one factor cannot be dispositive over other factors, full stop. It does need to be a part of a true balancing test. And uh, And so when reviewing public comments in support or opposition to a proposed facility, the board shall balance the benefit or impact referenced in the public comment against other factors already considered by the board. So really looking at the substance of the comments in support or against, and weighing that against the other information available in the evidentiary record. And continuing the dynamic citing process.
Thanks, Karin. And Jessica, if you want to go ahead and prompt the last polling question. We have 3 minutes left technically in the hour. And this last question is really to kind of get you all thinking if you have specific factors you think the Ohio Power Siting Board should consider when it comes to the public interest. We'd love to hear your thoughts. But we are going to try and dive into the Q&A. Nolan and Karin, I don't know if either of you have hard stops at 1:30. I want to be cognizant of attendees' times. We can maybe go a few minutes past to do some of the Q&A that I know of folks have put in the Q&A function here. After this polling question, though, if anyone does have a hard stop of 1:30 for the attorneys on the call, Jessica's going to be sharing a survey link for you to complete in the chat. Please make sure that you complete that. If for whatever reason you don't get that link or you lose it, we'll send it out to folks who tuned in as well. But just make sure you complete that if you're seeking CLE credit. But now let's turn to the audience Q&A. I think one of our first questions that we received, Nolan and Karin, was how close is the Ohio Supreme Court in making a ruling on how SB 52 only covers solar and wind and not fossil fuel projects? My first stab is I don't think that's a question before the court right now. I don't think the way that it's written, the only part of SB 52 that is just solar and wind is the exclusion zones. Hopefully as you listened to today, you kind of got the impression that it's an open question as to whether or not the board's approach to solar and wind cases when it comes to denying them will end up applying in fossil fuel projects. But that question hasn't risen up to the Ohio Supreme Court specifically. Karin, do you have anything else to add there?
Yeah, so to remember that SB 52 actually didn't make any changes to the statutory prongs that the board must consider when providing a certificate. And so really SB 52, all it did was say that in wind and solar cases, you get an ad hoc member if it's a partially grandfathered case or if there's no current ban, and that the county can create restriction zones where solar is banned, and no one has challenged that. The law is very clear that only applies to wind and solar cases, and so I don't think the board would offer ad hoc votes in a natural gas case. And so I don't know that it's really ripe for challenge as to whether SB 52 applies only to wind and solar. I think the real challenge is the OPSB's interpretation of the public interest prong, which was not altered whatsoever by SB 52.
So this next question, I really appreciate this question. I think it's an important one. How is OPSB staff accounting for fabricated or AI generated comments, if at all? OPSB rejected Crossroads last week. There was evidence that comments were fabricated. There's evidence that that's happening in other states too. Um, we've seen fabricated comments in some other situations outside the OPSB context too. My quick answer to this is that they're not really addressing it. Karin, you may have a different thought. I don't think they really are addressing it currently.
I have not seen any explicit analysis. I have seen in different decisions maybe references to a lot of comments being anonymous or something like that. But reading between the lines, I think one way the board's staff recommendations and this sort of trending towards using local government resolutions as a bellwether is almost their way of sort of taking the tone of what's actually going on versus what are bot generated comments. That is wholly my own sort of personal guess. There's not been a lot of analysis provided to us in the staff reports or board decisions that give us a clear indication of how they feel about anonymous comments versus comments with addresses attached, comments with real addresses attached. To our knowledge, the board does not, vet comments. If there's an address there, they take the address for what it's worth. Similarly, petition signatures versus a comment. Form letters versus someone writing something that's substantively different than what someone else said. There's not really been a lot of analysis from the board on that, and the OEC has said that's really kind of a black hole here to get into, or a rabbit hole of sort of tallying the persuasion of a comment based on whether it's a petition or a form letter, or the substance is unique to that individual comment. It's really, what's the substance itself? Is it is it supported by record evidence? How can it be mitigated, if at all, through project conditions? That's really the important part, though, and the way we hope the board goes, rather than trying to fall into this sort of matrix of weighing comments, which just takes it further down this existing road of sort of taking the tone, as board staff, a term that board staff have used several times, sort of taking the tone of the room, the tone of the comments, and the general presence of opposition versus substance.
And Nolan, just real quick, I'm curious if this issue has come up at all in your legislative conversations.
A little bit, not very much, but folks are aware of it. I don't know if it's reached the legislature as much. I mean, they're aware of it, but I haven't heard it necessarily as something they're wanting to address as of right now. But this story has certainly reached them.
Yeah, that makes sense. So now we have this other question. I think this is a really important one. Are only local government officials given a say on approving siting of facilities? If so, why? If the facility will add to the overall energy grid, shouldn't all Ohio governments have a say of what the public interest is? It's a little bit of what we've been discussing here today. I will say, importantly, local government, the townships, and then the counties that can create these exclusion zones, the township trustees get the opportunity, whoever they appoint, sometimes they appoint county commissioners, sometimes they appoint township trustees to be those ad hoc voting members on the board. So they get an additional say, but they can't, like, those ad hoc members can't override the board on its own. They could both vote no, and the rest of the board could vote yes, Or they could arguably vote yes along with some other folks, and the rest of the board could vote no and still be overridden. So they get input through there and through that process for these solar and wind projects. But your question more broadly about shouldn't all Ohio governments have a say here? Karin, do you want to talk a little bit about like how the board has kind of approached other governmental entities weighing in on these cases?
They've, I think varied reactions, if I'm not mistaken, Chris. And sometimes, depending on its case by case basis, how much they highlight or view as persuasive, other local governments weighing in. I think, the main argument during SB 52's debate and passage, and what we see in a lot of the decisions from the board is this idea that because the area where the project is sited, the people living next to it will have the most direct impacts. Those are the ones, the opinions that are going to be elevated over others. Those are the people that should be at the decision-making table. And so there's really a look at sort of the public nuisance, drainage, construction, or public nuisance, sorry, not in the legal term, of course. I wasn't using that as a term of art, but just a more colloquial way to refer to how some people view projects as unsightly. But the view shed, the drainage, the construction, traffic, all of those things remain sort of a precedent over the impacts that we all feel from climate change. And so that's really seen more as a broad amorphous threat compared to as of today at the board. Compared to what someone living next to it and their sort of view shed and traffic patterns.
So I think this is our last question that Nolan, I think you may know the answer to better than me or Karin, which is how close did Crawford County's referendum effort come to getting on the ballot? And do you recall who spearheaded that campaign? Any thoughts as you compare it to Rutschilling County now? Also, one of the pro-ban arguments in Rutschilling County is that it should be up to townships and it's not the business of other voters in the county. Comments?
Sure. So the Crawford initiative didn't make the ballot. I don't know the exact number of signatures that they thought they had or that they had, but I know they thought they were close, certainly, but they didn't. They didn't reach what they needed to reach. So that's as much as I know there. But I think um, the developer played a large role in gathering signatures, and that's very different than what's happening in Richland County because Richland County doesn't have a proposed utility scale solar project as of now. So this ban was passed by the county, and it's being led organically, I would say, by community members. And so that's what's really compelling about this is that, local and statewide groups are supporting to the degree the local campaign wants that support, but it's being led by the residents, and I think that's really really important and sort of just why this campaign is connecting with folks. And in terms of the comment around the townships, I'm just going to pull it up to make sure I read it right. Is the pro ban arguments in Richland County making it around the townships? I mean, the ban is countywide, and it's not a ban that's been enacted by a township. It was enacted by the Richland County Commissioners. So, I think from the standpoint of our organization, which values democracy, we have no problem with voters in that county being able to weigh in on the decisions made, especially because it's one of the provisions of Senate Bill 52 that they have the right to do that. So that's how I would and that's how I would respond initially, but I haven't heard much discussion on that myself.
Thanks, Nolan. And I think our last question was actually answered after it was asked through the kind of like someone was asking about what legislative changes might need to be made. We've given some thoughts already here, but I think we're at 1:40 now. We're 10 minutes past. I think we're going to close out the webinar. We really appreciate everyone joining us today. Definitely, if you wanted CLE credit, make sure you've completed that form. There will be a recording of this as well. And really just appreciate everyone joining us. This is our first Law Center webinar of the year. We will be hosting these every few months. So stay tuned for information on the next one coming up in a few months. All right. Thank you all.